Dear Prime Minister of Mandela, I'm Lau Jia En, your legal advisor. In my presentations, I will go through the first optional protocol to the International Covenant on Civil and Political Rights and the concept of reservations. I will also explain and analyze whether Mandela can enter a reservations to Article 1 as suggested by the member of the Cabinet. The ICCPR is a fundamental international human rights treaty providing a range of protections for civil and political rights. It obligates countries that have ratified this treaty to uphold and protect basic human rights such as the right to life and human dignity, equality before the law, freedom of speech, and so on. State compliance with the guarantees of the ICCPR is monitored by the Human Rights Committee, consisting of acting independent human rights experts elected by the state parties. There may not be more than one committee member per state party, which ensures that various legal cultures are represented. The committee monitors implementations of the ICCPR by its state parties and publishes its interpretations of the content of human rights provisions of the ICCPR, known as general comments on the thematic issues or its methods of work. In order to further achieve the purposes of the ICCPR and the implementations of its provisions, the first optional protocol came into force in 1976 on the same day as the ICCPR. The state parties considered that it would be appropriate to enable the Human Rights Committee to receive and consider communications from individuals claiming to be victims or violations of any of the rights set forth in the Covenant. Communications may only be submitted against a state that has ratified the first optional protocol and after all domestic remedies have been exhausted. The protocol establishes an international mechanism for the review of this complaint, thus providing individuals with an additional layer of protections for their civil and political rights. As its name makes clear, the protocol is not compulsory, but once a state party to the Covenant also becomes a party to the protocol, any person subject to the jurisdictions of the state party may lodge a written complaint with the Human Rights Committee, subject to any permissible reservations. A complaint can be brought only against a state that satisfies two conditions. First, it must be a member to the treaty in question, having ratified or accepted it. Second, the state parties must have recognized the competence of the committee to consider complaints from individuals. In the case of ICCPR, a state party recognizes the committee competence by becoming a party to the first optional protocol to the Covenant. Anyone can lodge a complaint with a committee against a state that satisfied these two conditions, claiming that the rights under the relevant treaty have been violated. However, legal aid is not provided under this procedure. Complaints under the optional protocol that contain the necessary elements are referred to the committee's special rapporteur on new communications to decide whether the case should be registered under the optional protocol and issue any pertinent instructions. If the case is registered, the committee's usual course of actions is to consider the admissibility and merits of the case simultaneously. To this end, the state party against whom the complaint is directed has 6 months to present its submissions on the admissibility and merits of the case. If the state parties fail to respond to the complaint, the state party will receive 2 reminders after the 6-month deadline has passed. Given the large number of cases brought under the optional protocol, there may be a delay of several years between the initial submissions and the committee's final decisions. The committee's decision, which is called a view, is not directly legally binding. However, states have accepted the committee's competence to interpret the ICCPR. Hence, if the committee finds a human rights violations, state parties have an obligation to repair these violations under the provisions of the ICCPR, which are in turn legally binding. The procedure, although written and confidential, can be compared to court proceedings. However, it should be noted that there is no appeal against committee decisions and that the decisions are final. The intention of the Covenant is that the rights contained therein should be ensured to all those under a state party jurisdiction. To this end, certain attendant requirements are likely to be necessary. Domestic laws may need to be altered properly to reflect the requirements of the Covenant, and mechanisms at the domestic level will be needed to allow the Covenant rights to be enforceable at the local level. Therefore, if Mandela becomes a party to the first optional protocol, Mandela is automatically deemed to have agreed to the recognition of the competence of the Human Rights Committee to consider complaints from individuals. Individuals under Mandela's jurisdictions will be able to submit complaints to the Human Rights Committee if they believe their rights under the ICCPR have been violated and they have exhausted all available domestic remedies. Mandela will be subject to international scrutiny and must respond to any findings and recommendations made by the committee regarding individual complaints. Also, Mandela would be required to respond to complaints within 6 months, promoting timely and structured responses to alleged human rights violations. Mandela might need to review and potentially amend its domestic laws and practices to ensure they are in line with the ICCPR to avoid adverse findings by the Human Rights Committee. Last but not least, the first optional protocol enhances accountability by allowing individuals to submit complaints to the Human Rights Committee, which reviews these complaints and provides recommendations. Secondly, a member of the cabinet has proposed that Mandela should enter a reservation to Article 1 if they become a party to the first optional protocol. Under Article 2, Paragraph 1d of Vienna Convention on the Law of Treaty, a reservation is defined as a unilateral statement made by a state when signing, ratifying, accepting, or acceding to a treaty whereby the state proposed to exclude or alter the legal effect of certain provisions of the treaty in their application to that state. It allows states to modify their obligations under a treaty to better align with national laws and policies. While under Article 19, a state may formulate a reservation unless the reservation is prohibited by the treaty or the reservation is incompatible with the object and purpose of the treaty. The ICCPR and its optional protocol do not expressly prohibit reservations, which means reservations are permitted. In order to make a reservation, states should institute procedures to ensure that each and every proposed reservation is compatible with the object and purpose of the covenant. It should take into consideration the overall effect of reservations, as well as the effect of each reservation on the integrity of the covenant, which remains an essential consideration. It is desirable for a state entering a reservation to indicate in precise terms the domestic legislations or practices which it believes to be incompatible with the covenant obligation or reserve, and to explain the time period it requires to render its own laws and practices compatible with the covenant, or why it is unable to render its own laws and practices compatible with the covenant. Reports to the committee should contain information on what actions has been taken to review, reconsider, or withdraw reservations. However, states should not enter so many reservations that they are in fact accepting a limited number of human rights obligations and not the covenant as such. According to Guideline 3.1.5 GPRT, a reservation is incompatible with the object and purpose of the treaty if it affects an essential element of the treaty that is necessary to its general tenure. Also, Guideline 3.1.6 GPRT states that the object and purpose of the treaty is to be determined in good faith, taking account of the terms of the treaty in their context, in particular the title and the preamble of the treaty. In Ballot against Switzerland, the Swiss government relies on its interpretative declaration purported to limit Switzerland's obligations under Article 6. The ECHR found that the reservations was deemed to undermine the object and purpose of Article 6, which is to ensure the right to a fair trial. Reservations that contradict the core principles of the treaty are incompatible with its main functions. Consequently, the reservations was invalid and Switzerland was bound by Article 6 without any reservations. As illustrated in Guideline 2.6.6 GPRT, a state or an international organization that formulates an objection to a reservation may oppose the entry into force of the treaty as between itself and the author of the reservations. There are two fundamental possibilities. The provision to which the reservation has been attached applies in full, or the state that made the reservation is no longer a party to the treaties. The reservations to the Genocide Convention case is a significant advisory opinion issued by the ICJ in 1951. In this case, some states, when ratifying the convention, made reservations to certain provisions, which led to a legal debate on whether such reservations were permissible and if so, under what conditions. The ICJ then held that a state could make reservations to the Genocide Convention provided that the reservation was compatible with the object and purpose of the convention. Compatibility should be assessed on a case-by-case basis. Furthermore, other states have the right to object to reservations. If a party to the convention objects to a reservation which it considers incompatible with the object and purpose of the convention, it can consider that the reserving state is not a party to the convention. However, if a state objects to a reservation but does not explicitly state that its objection precludes the entry into force of the convention between itself and the reserving state, the convention will be enforced between them, except for the provisions to which the reservation applies. If a state objects to a reservation and states that it precludes the entry into force of the convention between itself and the reserving state, the convention does not come into force between those states. The advisory opinion clarified the legal framework for making reservations to multilateral treaties, especially human rights treaties like the Genocide Convention. It established that reservation must align with the object and purpose of the treaty, and it provided a mechanism for other states to assess and respond to reservations. Nevertheless, the possibility of entering reservations may encourage states which consider that they have difficulties in guaranteeing all the rights in the covenant nonetheless to accept the generality of obligations in that instrument. Reservations may serve a useful function to enable states to adapt specific elements in their laws to the inherent rights of each person as articulated in the covenant. However, it is desirable in principle that states accept the full range of obligations because the human rights norms are the legal expression of the essential rights that every person is entitled to as a human being. Article 1 of the first optional protocol states that individuals who claim their rights have been violated by a state party to the ICCPR can submit written communications to the Human Rights Committee. It is fundamental to the individual complaint mechanism as it allows individuals to submit complaints to the Human Rights Committee regarding violence of the rights set forth in the ICCPR. A reservation to this article would effectively undermine a means to seek redress at an international level for violations of their civil and political rights. Indeed, the Human Rights Committee has previously indicated that reservations to Article 1 of the first optional protocol are not permissible as they would effectively nullify the individual complaint mechanism. The issue arises as to whether reservations are permissible under the first optional protocol, and if so, whether any such reservations might be contrary to the object and purpose of the first optional protocol itself. Its object and purpose is to recognize the competence of the committee to receive and consider communications from individuals who claim to be victims of violations by a state party of any of the rights in the covenant. Accordingly, a reservation that seeks to preclude the committee competence would be contrary to the object and purpose of the first optional protocol. On the other hand, reservations often reveal a tendency of states not wanting to change a particular law. Sometimes that tendency is elevated to a general policy. Of particular concerns are widely formulated reservations which essentially render ineffective all covenant rights which would require any change in national law to ensure compliance with the covenant obligations. When there is an absence of provisions to ensure that covenant rights may be sued in domestic courts, and further, a failure to allow individuals' complaints to be brought to the committee under the first optional protocol, all the essential elements of the covenant guarantees have been removed. Therefore, entering a reservation to Article 1 would essentially undermine the very essence of the optional protocol, which is to permit individuals' complaints. Such a reservation would be considered incompatible with the object and purpose of the first optional protocol. The Human Rights Committee and other state parties would likely view this reservation as invalid. Consequently, Mandela should reconsider making such a reservation as it would not be in line with international legal standards and could lead to disputes or criticisms from the International Committee. In summary, becoming a party to the ICCPR and its first optional protocol would significantly enhance the protections of civil and political rights in Mandela. However, it is advisable for Mandela to refrain from entering a reservation to Article 1 if it decides to become a party to the first optional protocol, as it would likely be deemed incompatible with the optional protocol's object and purpose and be invalid. That's all for my presentations. Thank you.